what's the further point they raised? And the conflict rule, when they say we should take the law of Zambia to... So Lex 40 seems to be common cause. We're in the forum of Pretoria, they chose the court here, no issue about the forum. So the Lex 40 there's an issue about. Based on that, I refer to the characterization test. And they say because there's only one foreign element, and that is that the deceased is a Zambian national, this court does not have jurisdiction. It is rely on that common cause. All of the other elements and connecting factors brings them back actually to South Africa. And those connecting factors is, if you look at a part delicta, the delict, if you want to call it a delict, was transpired in South Africa. The death transpired here. If you look at the interdict, they're seeking a South African interdict to be enforced in a South African country. The wishes of the deceased family, with all due respect, rely on agreement. All of that was reached in South Africa. The connecting factors doesn't favor the applicant to apply the Zambian law with all due respect. If one wants to even Zambian law, again, I need to play devil's advocate here and deal with it. The Kahunda matter doesn't take it further for the applicant. It's a review, doesn't go into the roots of the application. That's clearly stated in that judgment. It dealt with a Zambian who did receive his benefits and was not a normal citizen. So the Kahunda matter doesn't really help them, with all due respect. It's differentiatable to the matters before the court now.
What about the reasoning of the court, of the court in that matter?
Well, the public interest was because it's the it's the late president.
Well, we have a late president.
No, we do not, my lord, with all due respect.
Is this not a late president?
If he was treated as a late president, we would not have these issues with all due respect. His benefits and everything was taken away.
Is he not a former president?
He is a former president.
So what did he do?
With regards to how he was treated, he wants nothing to do with the current president. And that is completely understandable, taking the context of this matter. If I were to have, or any person to have, and it's not about who's right or wrong, it's to see the context here. I have any gripe with my brother, and I do not want him to preside over my funeral. And those wishes, this court will give effect to. Like I say, rightly or wrongly, doesn't matter. Practicalities aside, doesn't matter. The wish of the deceased is that the current president must not be there. And in fact, he said it on numerous occasions. This podcast, there's his own words about how he was treated, and one can understand that he doesn't want the current president to preside over his funeral.
Mr. Wilkenwood, can you clarify me on this point? Should this court consider the wish of the deceased or the wish of the wife and the family?
If the wish of the deceased can be ascertained to be buried, this court needs to enforce it. If it can't be, you look at, according to South African law, and even the cases my little friend, senior friend refers to Singadi and the like, all of those cases in South Africa, you look at the deceased, does he have a will, does he say where he wants to be buried? If he doesn't, if we can't make that call, then we look at his wife, basically. If it's now his customary wife or civil wife, we need to find out who's his wife in terms of all of those decisions, and we look at, and then maybe the next of kin, the siblings and the like. Those are the cases law in South Africa.
What is the wish of the deceased? Where did the deceased want?
I cannot make that supposition.
The wife?
The wife wants him to be buried here.
Was there no arrangements that he should be taken to Zambia through?
There were certain negotiations shortly after his death about whether or not to bury him in Zambia or not. All of those negotiations, offers, counter offers, all fall flat, and there's no agreement to it. The wish as it stands here, as contained in the answering affidavit, is that he be buried here.
Good, proceed.
That's important. And if one wants to say there is some type of Zambian law that needs to be applied. All of that still needs to pass constitutional muster. It must not infringe any decision of this court. Ultimately, must not. We're dealing here with a very personal right of the burial issues of any person. And the court cannot, or the applicant cannot, infringe on the following rights. Section 10, the dignity of the deceased. Section 15, the freedom of religion. 30 and 31, the rights of cultural practices. Section 12(2)(b), security and control over one's body, which includes the deceased body. This court ultimately must find, whatever the decision is, that it does not infringe on these rights. So even if Zambian law is to be applied, it needs to be tested against the Constitution. And that's those rights that are now presented to the court.
And how would it infringe the cultural rights?
Well, the cultural rights in all of the matters, my lady, and even in some of the Zambia matters that's been referred to by one other learned friends, the family's wishes is pretty much pertinent and of paramount importance.
So that's the only thing you're referring to?
With regards to the...
cultural rights?
Yes. And then, in this instance, the dignity of the deceased, he made it very clear that it would be against his wishes and, according to him, undignified to be buried when the current president is presiding over his funeral. Again, no question about if it's right or wrong. It is his wishes. Then, my lady, I'll deal with the... I still have a few minutes. My lord, I'll deal with the conditional counter-application and specifically the condemnation that is being objected to. So condemnation is in essence being sought for a period of 5-6 days roughly, which I would submit is not a great degree of lateness, taking into account the following: the type of application, time periods that the parties had to comply with, the very real situation that everybody wants finality to these proceedings, and in the interest of justice, I would submit that those the facts and the pleadings, because the affidavit must contain the facts and the pleading, therefore we had to file the conditional counter-application to align our pleadings with the facts, something the applicant chose not to do any further with regards to what type of relief they sought. They sought a declarative, they didn't seek specific performance in period 1 there. So we needed to align everything to make sure that everything's before court, everything is properly ventilated. The facts that we rely on, which the applicant says is non-existent in that affidavit, is existent. We rely on all the facts already stated, the representation, the impossibility that they have met to say if there's a breach, it's not material, and in any event, it's impossible to agree to such a term because the president will be there. And then obviously the undue hardship has already been dealt with. It will be undignified to force the respondents to have the current president preside over the funeral of the late president.
Sorry, are you saying we must read those factors in?
Those factors are dealt with because we incorporate the factors of the answering affidavit in the counter-application. We start off by saying everything that's said in the answering affidavit is applicable. The reason why the conditional counter-application was filed is to bring into a conditional counter-claim, which is just the prayers need to align with all the facts. So we're saying there's no agreement, but we're saying, for argument's sake, if the court might find that there's some sort of agreement, we need to plead in the notice of motion, in the counter-application, that it is impossible to enforce that agreement that they then suppose or present to the court as the agreement. We then need to say that there's undue hardship and that specific performance under these conditions can never be granted because it is subject to the Constitution and the rights of the family. And
Here are the facts for this conditional counter-claim.
in the answering affidavit and in the affidavit itself.
So we must go and look for it in the application for condemnation.
No, well, I didn't
Consider the application for condemnation. We must go and look for facts in the answering